Great.
All right, it's all yours.
Thank you.
Good afternoon, everybody. My name is Paul Barden, and with me is Paul Isaac Jr. We're from Paramount Settlement Planning and Precision Resolution, and we appreciate the opportunity to come speak to Dutchess County about some of the services that we provide as plaintiff-focused settlement planners. Next slide, Paul. So we've been in this business since 2003, so this is year 18 for the firm, and here's a picture of our team. As you can see from the pictures and the acronyms that follow the names, more than half of our team are in fact attorneys, former trial attorneys, and the other half are financial services professionals. So we have a robust team that's available to tackle the large array of challenges that are presented to us in some of these more complex settlement cases. Some of the acronyms following the ESQs, you can see that in addition to the attorneys, we have people that have specializations in special needs consulting, in Medicare set-aside consulting, and in secondary payer, Medicare secondary payer certifications. So we have a robust team that has a lot of years of not only legal experience, financial experience, but experience with all the nuances of the various issues we see in these cases. Next slide, Paul. First and foremost, it's important to know that we are advocates for plaintiffs only. We work for the plaintiff. We don't work for an insurance company. We don't work for the defense. We work for the plaintiff. And in order to work for the plaintiff, first and foremost, we need to understand the plaintiff. The foundation of any settlement planning is knowing and understanding the plaintiff. And why do we only work with plaintiffs and not the defense side? Is because to get to know the plaintiff, you need to spend time, hopefully before the case is resolved, to understand what the injured person has gone through to get them to where they are in their case, so that we can put together a plan that's fashioned and tailored to that particular client. There are no cookie cutter solutions here. We have to take into account government benefits they might be receiving or need to receive, new housing arrangements, a vast array of issues that we have to take into place. So we can only do that by getting to know the plaintiff. So we are not out, we're not salespeople. We don't sell a particular plan or product. Our goal is to craft a plan that's right for our clients. Next slide, Paul. So let's just talk a little bit about the process. And I should back up and say that this is the settlement process in a personal injury case, right? So what we're talking about with structured settlements are unique to a plaintiff personal injury case. And to get us from the beginning to the end of the case, we obviously have a case intake where we'll take information. We have a number of forms that facilitate that process. We're going to gather that information, not only analyze the information that we might be provided in writing, but typically meet with the client, the patient, and their attorney, oftentimes, many times more than once, to understand as we work through the plan. We're going to craft a variety of settlement solutions. As I said, there's no necessarily cookie cutter answer. And so, we're going to craft some ideas, and then we're going to meet with the client again and let them kind of pick and choose what pieces of what plan might be best for them and their solution. And obviously that's not only the client, but their family, and perhaps even the guidance of their attorney who's been working with them. We're going to take all of those things into consideration. And then we're gonna take that chosen plan. And as I said, we're not really salespeople and we're not beholden to a particular company. So we're going to take that plan and then shop it against all of the various products that are out there across the marketplace. We don't have a particular company necessarily that we work with. So we're able to look at that across the whole market and find the best rates and the best product for that particular plan that we've come up with. And then we're going to prepare all the settlement documents. So that's in most cases a settlement agreement and release, a qualified assignment, and various other documents. In a wrongful death, it might be the entire wrongful death petition and application to the court. As I said, is one of the advantages of having as many lawyers as we do, is that not only can we prepare a plan and come up with a plan, but we could actually prepare the legal documents to facilitate the final resolution of the case. Takes a huge burden off the plaintiff's lawyer, who may be good about getting the case settled, but has less knowledge about how to get those settlement documents in a form to protect the client and to protect the attorney in years after the resolution is finished. Okay. So in a large sense, there are a number of structured settlement benefits. The first and foremost is it's guaranteed and tax exempt. So once a structured settlement is in place, there's always a guarantee, meaning that money is going to be there as promised on the date that it was promised and delivered. As you know, the personal injury settlements themselves are tax exempt at the time that they're paid. If the client took a lump sum payout at the beginning, at the settlement of the case, that money would be tax exempt when they received it. But then if they go and invest it, any proceeds from that investment are no longer tax exempt. A structured settlement payment, if you had a periodic payments over a period of time, each of those payments, when they're made, retains their tax exempt status. As I said before, there's no cookie cutter here, so our products, our plans are customizable and unique. Hundreds upon hundreds of plans. I can't think that we've ever really done the exact same plan for any one particular client. Everyone has unique needs, timelines, and things that they're trying to accomplish. So very customizable. No ongoing management fees. There's very little fees associated with structured settlements. The money is held by a life company. That life company does not charge any ongoing management fee. So you might have a payout of 10, 15, 20 years life, whatever it is. There's no ongoing fee. So you know what amount of money is going to be coming out for payments, but there's no other fees associated with that. If the client in some future year has challenges with a bankruptcy, those payment streams are not subject to the bankruptcy court or the trustee. So an important protection, particularly if there's a client who's in somewhat financial peril, perhaps due to the circumstances of their injury. And then, so in terms of building blocks, structured settlements is often just a piece, or actually structured settlement is somewhat of a misnomer itself, because a lot of people say, well, structured settlement, that means a periodic payment stream. Well, we look really at structured settlements as being one of, it has multi-components. So you have a periodic payment stream. There's always typically a cash payment to take care of immediate debts, pay off things like a mortgage, and then in the right cases too, there might be a third leg, which is market-based investments. We look at all of those components together, and depending on the circumstances of each case, we might recommend one, two, or all three of those legs. So, but as a general principle, that those guaranteed periodic payments creates the strong foundation from which you can build those other pieces. In terms of structured settlement solutions, we do infant and minor settlements. You know, the state law in New York pretty much requires a payment to an infant to come out of a bank account at age 18. Well, not so with a structured settlement. We can extend those payments past the age of 18 to protect both the proceeds and, you know, really protect the minor from themselves. So we might you know, have a little bit of money coming out at 18, but then some more money coming out to say pay for college or to make a down payment on a home and things of that nature. We're always looking for preservation of government benefits. So again, this person might be on Medicaid or Medicare. Medicaid has very limited resource tests. So we might have to have the you know, structured settlement paid in such a way as to keep them under threshold, or perhaps paying into a supplemental needs trust or something like that to preserve those benefits. Retirement planning, I'm going to get into this for a little bit more on the attorney fee structure, but in terms of retirement planning as an annuity or periodic payments, is being able to defer payments out to a period of time later. So say that 40, 50-year-old client doesn't want to take all the money now. They may be able to return to work part-time or on a limited basis, but want to have money later for retirement. You know, we can defer payment out to a period of time where the structured settlement really becomes one of the key components of their retirement. And then Medicare set-asides. You know, in cases where a Medicare set-aside is required, we can have, rather than taking a huge lump sum of money and placing it all in a bank account waiting to pay the fees or the costs of medical care that are covered under the set-aside, we can have those periodic payments paid in, say, annually to fund a Medicare set-aside so that that money's working for the client over in the life company and only paid out in increments necessary to meet the expenses of their Medicare set-aside. And then attorney fee deferrals is another structured settlement option, which I'm going to talk about here in a minute. So as I said, we work only with the plaintiffs, and our job from the time the case is settled is to really take the burden off of the attorney almost altogether. We're going to do the settlement document and drafting. We're going to be the ones who talk to the defense attorney and the defense broker, work out any issues they might have with the draft of the papers. Sometimes we're the ones who receive the papers, and then we'll have to review all the papers that have already been drafted. And we have developed, you know, an extensive checklist of items that we're either going to reject outright or edit in settlement papers to protect both the client and the attorney. And then in terms of lien amounts, the precision resolution, which Paul's going to talk about in a minute here, is looking to make sure that all of those liens are in fact identified and resolved prior to the payment of any fees in the case. So a couple of key tips. The largest being avoid a general release. Sometimes we get the call from attorneys after the case is settled. They said, "Hey, case is settled. I've signed this general release, and you know we'd like to structure some of the funds." Sometimes that can be too late. Signing a general release can result in what's called constructive receipt of the funds, which then, you know, extinguishes the tax exemption. So if and when you think you're going to settle a case and there's going to be a structure, don't sign any general releases, don't receive any monies, call us first and we'll take it from there. There are some minimums. $10,000 is the minimum that a life company in the state of New York will accept in terms of a structured settlement. So that's not a lot of money, but we have done a number of particularly infant settlement cases that might have only had $10,000 or $15,000. Again, putting that little bit of money in a bank account only does so well. We can do better with that money for an infant and protect it beyond their 18th birthday. Know that rates are always changing. We see rate changes nearly every week. So if we quote a case, say a couple of months ago, as you're thinking about what to do with a case, and then the case is resolved, we will have to requote those to make sure that we're getting an accurate quote based on the current rates. And those rates could go up or could go down. So we'll always make sure to rerun those quotes at the time that the case is resolved, so the client knows exactly what their case is going to be paying out.
Paul, if you could talk about the difference. You just explained how rates will change while maybe the case is ongoing or the client is making a decision. Once earlier on in the presentation, you talked about guarantees and how those amounts are guaranteed. At what point does the benefit, the payout that's illustrated, become guaranteed and not subject to any changing rates?
Once the case is actually funded. Until the case is funded, you know, those things can change.
So great. Once the case is funded, the client is presented an illustration, which again shows the benefits that they're going to receive on the dates selected based on our conversations and fact finding. And those are the guaranteed amounts that they can anticipate receiving either for the rest of their life or on the fixed dates that they've selected. Is that correct?
That's right.
Great.
Yeah, and then a lot of our settlements are funded based on a fixed date, you know, paid at age 18, age 21 or something. So again, in order to lock in the amount, we have to know exactly what that period of time is, and if we wait on that period, it could adjust the payout. And then we have a number of forms that we use in our office to help streamline this entire process. So if you do have a case that you would like to work with us on, we'll send you those documents. So let me just talk a couple minutes about attorney fee deferrals. You know, as I talk to attorneys across the state, I'm often surprised by how many don't realize that they can defer their own fees, and they know about being able to do it with their clients, but not as many know about their own fee deferrals. And there's some huge advantages to doing it, but let me talk about a couple of best practices here. First is if you're going to contemplate doing fee deferrals, we always advise that you inform your client up front in the contingent fee retainer that is contemplated. So we can provide some language that tightens up your contingent fee retainer in that regard. But your client should be aware of it at the outset so they're not surprised at the resolution of the case. And then during the negotiations, it has to be discussed during the negotiations, because the defense has to be a willing participant in the structuring of fees, whether it be the attorney fees or the client's money. So make sure that during any negotiations that you're actually make that part of the discussion. We've had attorneys call us to try and structure afterwards, and then the defense says, well, we didn't talk about that. That wasn't part of the deal. So that can create problems if it's not talked about during the negotiation process. So some real advantages here: guaranteed retirement. You know, most attorneys and firms have some kind of 401k plan. Obviously, the amount of money you can put in a 401k in any given year is limited. So there's no limit to how much you can structure in a year, and there's really no limit on how that you can have those payouts happen. So for example, you don't have to necessarily wait till you're 59 and a half to pay it. If you want to have those fees paid sooner, say you want to retire at 55, well, you can do that. I have a lot of attorneys that want to try and bridge the gap. You know, there's you can start collecting Social Security at age 62, but if you wait till age 60, I'm talking about people that are born, I think, after 1942. 43. So if you wait till your full retirement age, 67, that will be better. And if you wait till 70, it's even better than that. There's an 8% increase every year you defer receiving your Social Security after full retirement age 67. So you can really maximize your benefits. So rather than take your Social Security at age 62, wait till age 70. We can create a product that would pay you from age 62 to 70, and we can recreate that payment stream, and then you can maximize the Social Security. Those are just some ideas that we've done in the past. Employee retention and firm expenses. So sometimes you want to have ways to pay bonuses or things like that to employees at the end of the year. That's an idea that you can do. Some firms, many firms, have to pay all their funds out at the end of the year in terms of bonuses or partner distributions, those kind of things. So oftentimes January becomes kind of a rough cash flow month. You could have the contingent fees paid into the firm over time. So rather than taking, let's say, the case settled for couple $100,000 in fees, rather than taking all those fees in 1 year, you could break those up and have those paid in January for the next 5 years, or whatever you want to say, in early January. So you have cash on hand at the beginning of the year to defray those costs that you might incur early in the year.
And important to note too that most of, in the traditional attorney fee structure setting, most of the life companies who participate will allow payments to be made to the law firm directly rather than to one specific attorney.
That's right. And so there's traditional fee structures, the traditional life company fee structures, as you see on the chart here. No management fees, essentially no fees whatsoever, with the guaranteed return and defense cooperation. One of the limitations, if you want to call it that, on these traditional fee structures is that once you settle on a payment stream, those are typically a fixed amount, fixed same amount over a period of time. You can't put in a cost of living rider, 1%, 2%, 3%, but that some attorneys don't like that. So the next slide here gives you a different vehicle. These are index-linked riders, which essentially are linked to, they're not market-based investments, but they're linked to how the S&P in fact does. So in years where the S&P increases, the payout increases to match up to 5% a year of the increase in the S&P. And even more advantageously, in years that the market goes down, it doesn't lose any value. It's going to retain whatever its percentage increase is and only capture those percentage increases. So this is really a way to build a cost of living adjustment into a better than a cost of living adjustment, because cost of living typically is 1.5%, 2%, and here you can really capture up to 5% return in increasing the payment stream over time. So these are becoming very popular to use as well.
Paul,
I think you're going to talk about some lien resolution stuff.
I am, and before I move on, there's 2 points I want you to just touch on and remind the audience. While we are not tax attorneys, we don't give tax advice. Talk again just briefly about the benefit of deferring fees, and then also the mentality, rather than waiting for that once in a lifetime case, how a lot of we advise our clients to kind of look at each case and handle it on a case-by-case basis. Just touch on those points quickly.
Yeah, so a lot of attorneys think, oh, geez, I'm not going to be able to do a fee deferral. I don't do big cases. I just kind of have run-of-the-mill cases. Well, we have quite a few clients actually, that attorney clients that are building a portfolio one case at a time. You don't necessarily need to structure all your fees and as I said, the minimum you can do is $10,000. So if you have a case, let's say, it's a $50,000 fee, you want to take half of that as income and half of it into an annuity, into a structure, we can do that. And you might do that if you start doing that on every case, taking a percentage of your fee and deferring it, you will build a portfolio, and we will use that kind of as a building block to say, okay, well, this one's going to pay for this amount. Well, we need another one to get it to this amount, or now we want something different. Maybe there's planning for a college education for a child or something. We can take a little fee from each one and help kind of build whatever portfolio the client wants to do.
Thank you, Paul. I'm going to speak very quickly about lien resolution, lien reporting, and the Medicare set-aside services that our group provides. Paul just talked to you about Paramount settlement planning, and I'm going to talk about precision resolution. We are a lien reporting and resolution firm focusing on single event cases, rather than a lot of lien resolution firms out there who handle mass tort cases. Our focus is single event, which allows us to look at each case individually, focus our attention on those cases to minimize the recovery by government, private health, insurance carriers, and put more money back into the plaintiff's pocket at the end of the case. Our firm offers a variety of solutions. It's not just lien reporting or not just lien resolution. We're very effective, and we have 2 full-time attorneys and a staff of 8 former personal injury paralegals who know the parties to report these claims to, whether it's a Blue Cross Blue Shield plan. We know where to go to report the claim and get an updated itemization so that you can focus on litigating the primary case, and you can settle the case with the confidence in knowing that we have reviewed all claims and you have an accurate picture. You take that back to your client, and it makes the settling of your case easier with those accurate amounts. Depending on a number of circumstances, those being jurisdiction and proper notice to plaintiff clients, the 2 main conditions, fees for the outsourcing of lien reporting and resolution may be charged as a case expense to the client, which again really favorably impacts law firms' bottom line. That's work that you and your staff don't have to do, and it can be a cost in the case itself. I'm just going to detail our fee schedule here briefly. What we do is we charge an upfront fee of $500 per lien, and then we're incentivized to reduce those liens and get them down, which is a net gain for both your firm and your client. We charge 15% of any reduction that we secure, and that does not include the traditional Medicare reduction in their final demand amount for attorney's fees and case expenses. A lot of the services you'll see on the slide that we offer, it's claim review, it's coordination of benefits. If we know that your client has had a hospital admission, but we are not seeing that hospital admission on Medicare's ledger, we're going to do a couple of things. We're going to come back to your office and say, hey, look, there may be other coverage at play here. Let's reach out to the client. Let's find out, were they covered under a Medicare Advantage plan? Did they have other coverage of the private insurance that may have covered that admission? All of this, all of the work that we do behind the scenes to uncover maybe hidden claims, at the end of the day, provides a more accurate representation of that lien amount to you and your client, again, so that there's no surprises when it comes to settlement. And there's a kind of an ease when you settle the case to know that everything's been uncovered. There's not going to be anything floating out there. No private health insurance carrier or Medicare Advantage plan is going to come back and sue you, the client, at the end of the day. Again, our focus is on single event cases. We're proud to say that we have reduced over $150 million in lien amounts over the past 10 years. And again, in single event cases, that's a lot of work. It's not just a blanket release for 2,000 claimants as part of a pool. We're diving into these cases. We're looking at medical records. We're looking at complaints, looking at state regulations and statutes to take back to government agencies, to private health insurers, and get those lien amounts reduced to put more money in the claimant's pocket at the end of the day. And lastly, one of the services that Precision and Paramount provide are Medicare set-aside solutions. There's a lot of questions surrounding Medicare set-asides. Are they required? Is it something that my client has to do? Is it something they should do? And Precision standpoint is generally they are not required in any case. But if you're dealing with a Medicare beneficiary or a soon-to-be Medicare beneficiary who is going to require future Medicare-covered accident-related treatment, it is always a good idea to consider Medicare's future interests and protect the Medicare Trust Fund. We have a number of solutions that help plaintiffs and guide plaintiffs' attorneys in doing so. Some are full Medicare set-aside allocation reports, which are projections of future medicals and prescriptions. And we have some options that are not as robust, provide cost savings in the form of a Medicare set-aside opinion letter, where we'll look at the case, we'll determine, hey, look, there's no fault coverage remaining. That is probably going to pay for future surgeries. And we may say in an instance such as that, there's no need to set funds from that settlement aside to satisfy Medicare's future interests. And again, as a plaintiff-only, plaintiff-focused practice, it's very important to us that at the end of the day, we put more money back into the plaintiff's pocket and are also providing a service where plaintiffs' attorneys can protect their practice. They can document their file, show their due diligence was done in every case, to again, close that case with confidence, know they got the best result for their client, and move forward. I think we've got a couple slides left, Paul.
Is that my cue, Paul?
Yeah, go right ahead.
Oh, sorry. Yeah. So I really like our mantra there, from litigation to living. It really is a very good descriptor of what we try and do. Clients have been in litigation oftentimes for many years, and all of a sudden they're at the end of their case and they're like, wow, it's finally over. It can be a real difficult time for them to get their head around that. So our team's job is to help them transition to life, that there is life beyond this litigation that's consumed their lives for quite often many years. And I think we do a good job of it. So there's our contact information. Those are direct dial phone numbers, emails. We'd be happy to field questions, and we field questions all the time. Just because you don't think your case necessarily neatly fits into something we've talked about here, call us and ask us. We enjoy engaging with attorneys and helping you figure out whether or not you even need our services. So when in doubt, pick up the phone, call us. We're happy to talk, and we look forward to doing that.
Absolutely. We're a resource for your practice, and if it's something that falls outside of the scope of our services, like Paul said at the outset, we've been doing this and protecting plaintiffs and looking at personal injury cases from a settlement planning perspective for almost 20 years. We can get you to the respected and trusted party.
Thank you guys so much. I don't know if there are any questions. If not, I will stop the recording.